Joseph. Do we have attorneys ready to proceed?
There. Appellant is ready, Your Honor.
Very good. And I think also we have Ms. Wheeler. Can you hear me as well?
Yes, Judge, thank you.
Very good. All right. So if we're ready to proceed, Mr. Marin, go ahead. And how much time would you like to say for rebuttal?
10 minutes.
1 minute? Very good.
10.
Oh, I'm sorry?
10.
10 minutes. We only allow up to 5 minutes for rebuttal, sir.
Oh, okay. 5 minutes.
Very good, sir. You may proceed.
Thank you, Your Honor. The first issue is that the court erred in admitting Dr. Afield's medical records into evidence. Dr. Afield actually testified in this case that Arlene Petroni's records were mixed up with another patient's records. Specifically, Dr. Afield testified that Arlene Petroni did not have reflex sympathetic dystrophy. She also testified to that fact. She never had that very bad condition. She did not have...
Mr. Mayor, if I may, just to get the background, the records that you're referring to, these were subpoenaed and they were considered as to be the actual, they're basically the record of the physician, correct?
Correct. Yes, ma'am.
All right. And how do you respond to the argument by counsel that your opposing counsel that because these are the business records, we're dealing with the issue of not the admissibility of the actual records itself, but actually it goes to the weight that the records are given. How do you respond to that?
I think that's absolutely incorrect because I think the rule is very clear. Under the rule, if the records authenticity or accuracy or truthfulness or veracity is called into question, then it is not an exception to the hearsay rule. First, they have to be admissible under the exception to the hearsay rule. Any record is hearsay unless it comes under an exception. The two exceptions are medical diagnosis or treatment records or records of regularly conducted business activity. And the rule specifically states under 90.803 subsection 6A, memorandum, if they come from a person with knowledge transmitted for the purpose of the visit with regularly conducted business, that's admissible unless the sources of information or other circumstances show a lack of trustworthiness. So
how is that, Mr. Merring? Explain to me, the request for patient records was made by patient name, patient date of birth, patient social security number, and the doctor says, here they are. So that seems to satisfy the business records exception. Now, to the extent there were documents intermingled, I don't think that goes to the admissibility of the business records so produced. I sort of share Judge Kuzam's point. It goes to the weight that the jury wishes to give in light of Dr. Afield's testimony that there was some mix-up in the documents. So that's what I'm trying to get at.
Mr. Merring, I think you may be frozen a little bit. Can you hear us, sir? Mr. Merring? We may have a little bit of a technical issue. Let's stand by. Mr. Merring, okay, you froze for a minute. We can't hear you, sir. Do you want to unmute? You are muted. Wonderful.
Can you hear me?
Now we could hear you.
I'm sorry, it just went blank.
No problem. No problem.
The rule specifies that it is not admissible. It is no longer an exception to the hearsay rule if there's evidence indicating that the documents are untrustworthy. How can you say these records are valid just because the subpoena was responded to as her medical records and then the doctor reviews the records and finds that those are not his patient's records? She most certainly never had reflex sympathetic dystrophy. and that came into evidence. She never had bursitis.
Am I correct, even as to those documents, Mr. Mary, they show her name, her date of birth, and her social?
Yes.
Okay.
And Dr. Afield testified that those were errors, that they were another patient's records mixed in with hers, that they are not her records. It was his office's error. Why should the plaintiff, the appellant, suffer because of a doctor's error? And the doctor admitted they were an error. And never has there ever been a case in all the cases that we looked at where a physician actually admitted that his records were incorrect. We have his testimony that they're untrustworthy.
Is it also correct that there are at least 2 or 3 documents that do reflect some pre-existing issues?
The only thing that was pre-existing was her sinus problems and headaches. Everything else was not Arlene Petroni. In court, he testified that maybe she had a pulled muscle and a pulled disc, but that was not her either, because she never had an MRI before this incident to show any pulled disc. It was not her. She never had fibromyalgia. She never had trigger points or bursitis or any discussions of surgery for carpal tunnel. She didn't have those things. And all of that came into evidence. That, at the very least, it should have been kept out to the extent that the doctor specifically testified that this was not her medical record. If they wanted to get in the other medical records where she was getting the medicines for the headaches, fine. But all of these specific things that were absolutely not Arlene Petroni were horribly prejudicial.
And that was conveyed, though, Mr. Mehring, at trial, was it not, where the jury heard, and I think she even testified that her ex-daughter-in-law went also to Dr. Afield. And so the explanation was made, and I guess I go back to that if the records were appropriate in the sense that Dr. Afield testified that it was his office's normal practice to keep those medical records, and they were kept in the normal course of practice. And then there was the fact that it was made by him, and it was a regular practice of the business to keep those records. And I go back to that if those business records were appropriate, then anything regarding the contents of it, anything regarding whether or not there was some concern with that, that goes into the totality for the jury to consider, as opposed to totally those things should have been totally excluded from the outset. I guess that's my concern, Mr. Mehring.
I understand completely. And that's the purpose of the hearsay rule to begin with, is it not? To keep out such records when they're questionable and not an exception to the hearsay rule. The burden is upon the defense to overcome the hearsay rule. And when there is a question of trustworthiness, they shouldn't come in. And you enumerated all of the elements, except you left out the information is provided to the physician by a person with knowledge. The only person that could have provided that would be the patient, and the patient did not provide that information. It did not qualify as a business record because Arlene Petroni never told those things to the doctor. It was a different patient.
But doesn't that also imply where Dr. Afield is the one with knowledge, is making those, is actually inputting the record? I think that's what it deals with the totality of.
No, it's not the physician with the knowledge. It's the person giving the information to the physician. That's not. It's the statement made for purposes of medical diagnosis or treatment by a person seeking the diagnosis or treatment, made by an individual who has knowledge of the facts involved. That's the patient, not the doctor.
Correct. But the doctor is the one that is inputting all that information into the business record. That's what is referred to.
Correct. And all of these conditions were from a different patient. How can that possibly be admissible? It's not an exception to the hearsay rule. Clearly, they're not trustworthy. They should not have been entered into evidence.
If they are indeed produced initially as the records of this patient, and Dr. Afield later says, oops, we had an office malfunction, doesn't that become a question as to whether or not Dr. Afield indeed had made a mistake?
He said he did make a mistake. But first of all, the records were not produced by Dr. Ayfield. They were produced by his office.
Ms. Mehring, is it for the jury to weigh these purport to be her medical records? Dr. Mehring says they're not. Can't the jury be in a position of deciding?
Absolutely not, because that's what the hearsay. I don't think that's what the hearsay rule is for.
Okay.
The hearsay rule is so the jury never hears this inappropriate, incorrect evidence. That's the purpose of these rules, to keep out evidence that should never be heard by the jury. That's not for the jury to determine. The rule is it's hearsay and inadmissible if there is an issue of untrustworthiness. That's it. They should never hear it to be confused by it. And this was sure confusing. It's not the plaintiff's fault that this occurred, and she should not have to suffer because of the doctor's error and these records come in. The diagnoses in these things were terrible. RSD, reflex sympathetic dystrophy, that's a horrible condition. She never had that. She never had bursitis. She never had fibromyalgia. Those are all terrible conditions, and they weren't her. And they should not have remotely come into evidence in this case.
Would you like, Mr. Mayor, to go through your next point on appeal?
Yes, ma'am. The other issue is Dr. Foley testifying about causation in this case based upon looking at MRI studies. There is no medical basis for him to conclude with that, more likely than not, that her discs in this case were degenerative in nature and not caused by trauma. There's just no scientific.
Oops, I think, Mr. Mehring, I think you froze again. Hopefully you'll be able to unfreeze. There you go.
Pardon me?
You froze for a minute there.
Oh, I'm sorry.
That's quite. There, now you're back. Now
okay, you're. Sorry. In State v. Cybers, the court found that the state failed to carry its burden of demonstrating that the expert testimony presented at trial was based on scientific principles and testing procedures that are generally accepted in the relevant scientific community. The only testimony offered to establish the general scientific acceptance of the state's procedures came from their own experts, each of whom had a personal stake in the procedure and was prone to potential institutional bias. Such assertions are not alone sufficient. Proof of general scientific acceptance requires the testimony of impartial experts or scientists as to both the underlying scientific principles and the testing procedures used to apply the principles to the facts. The scientific evidence must be shown to be reliable on some basis other than simply it is the opinion of the witness who seeks to offer the opinion. Dr. Foley indicated that he relied on the medical records and the MRI studies, the radiology studies that she had. The testimony he gave in his deposition indicated that he was not relying on any particular medical records. He was only relying on the films. That was on his page 29 and 30 of his deposition, October 8, 2011. Question years before, and I'm not talking about a one-day ache or pain when somebody works in the yard and goes wet. I'm talking about consistent, constant, repetitive, similar pain in the neck. Answer, well, I have no medical records on that. I would say that a patient with this degree of question, are you rendering an opinion, yes or no? Answer, degenerative change. I would say that a person that has this degree of degenerative change most typically would have symptomatology within their neck over the course of years.
And I appreciate that, Mr. Mayor, but I know you're making reference that at least you're concluding is that Dr. Foley merely relied on the studies, but didn't he also testify that not only did he look at the radiology study, he also reviewed your client's medical records, published articles, as well as his experience. I think he has 32 years experience, including a number of years, I think 25 years as an interventional radiologist.
Yes, ma'am.
Why isn't that appropriate and looking as to whether or not he could provide his opinion?
because there's no scientific basis in the medical records or in literature. There was not a single article that he showed that could enable him to testify that more likely than not, her pain was caused by degenerative problems as opposed to the trauma of the accident. He's just looking at the films. When, if I may, Your Honor, when I asked him in his deposition, all right, well then, are you relying on any medical records? You say you reviewed the medical records. What medical records specifically are you relying on? I want to know what you're looking at. The question was, so are any of your opinions based on any particular medical record or symptom or result? Answer, no. It's primarily based on the films with the medical records as a background. He never specified anything in the medical records that backed him up. He just said, looking at the medical records generally. There, if you go through the transcript, there's not one thing he points out. And actually, he testified and acknowledged that she never, ever had a single pain complaint in any medical record before this accident in her neck or her back.
And Mr. Mayor, you're about to reach 5 minutes into your rebuttal. You're welcome to go forward, or if you'd like to reserve the remainder for rebuttal.
Just that the case law is clear that an expert cannot himself testify and support that his methodology is scientific and accepted in the scientific community. Obviously, there has to be someone else to support that. There's nothing that would support his testimony that his experience and his review of the records and the films entitles him to say more likely than not that this accident did not cause her pain, even though she had no symptoms of pain before this accident. And it all occurred right immediately following this accident. It's nothing, there's nothing to back him up. Never has any other radiologist come in and testified that that is accepted within the community. And that's required by the case law. You can't just go to a Daubert hearing and say, I say so, so that's accepted within the scientific community. That does not satisfy Daubert. That's all.
Very good. So, and you have about 4 minutes for rebuttal then, okay? Very good. So if I could have you, I guess, mute your mic, and then Ms. Wheeler, we're ready for you, ma'am.
Thank you, Judge. First, starting with Dr. Afield, I would remind the court that Dr. Afield's records actually, that 2 of them, plaintiff actually called Dr. Afield at the trial about the records, and Dr. Afield himself testified that 2 of the disputed records actually applied to plaintiff. One of those records was, is the one where, well, let me get my records of June 4 of 2009 and November 28 of 2000. He said that those absolutely applied to the plaintiff. And those records, one of them indicated that she told him that she had apparently pulled a disc in her back. Either that or she pulled a muscle, and she was taking Lorset, which was a prescription medication. And I looked up the Lorset online, and it's a pretty powerful drug. In fact, I think it's considered a narcotic. So she had to have been having some significant pain at the time. And that was in June of 2009. And this accident occurred less than 2 years later in April of 2011. So I think that so far as Dr. Afield is concerned, that record alone established that there were some prior back issues. And then the other record was, he said he thought that was her also. And that one, let's see. Well, I'm sorry, I'm not finding it in my notes here, but regardless, I would remind the court also that Mr. Mehring actually moved Dr. Afield's records into evidence. So they were in there at his request, and then he called Dr. Afield, who testified that that record of in June of 2009 was plaintiff. So they were indeed relevant. They were material to the issues in this case. Dr. Afield, he produced them as business records. They qualified as business records. And at least those 2 records did apply to plaintiff by his own admission. I don't know if the court has any more questions about Dr. Afield's records, but there was no mistake, no reversible error with respect to Dr. Afield's records. With respect to Dr. Foley, I would remind the court that section 90.702 basically sets out the requirements that must be shown for admissibility under the Daubert standard. There are the 3 requirements. The testimony has to be based on sufficient facts or data. I think it's undisputed that Dr. Foley relied on the MRI reports, X-ray reports. He reviewed them, and he not only reviewed the records, reviewed the films, but he also reviewed the medical records and correlated the films with the records. And Mr. Mehring has never challenged that methodology, and I think that it was very appropriate. And the court is aware of, from many cases, I'm sure, that correlating the records with the films was absolutely an appropriate methodology, and it was a reliable method, as well as the principles that Dr. Foley applied. He applied them reliably to the facts. And again, this is where Mr. Mehring challenged. He really did not ever challenge Dr. Foley's methodology, which was applying a differential diagnosis, considering all the facts, and as well as her complaints. That methodology was not challenged. And it's our position that Dr. Foley applied the principles as well as the methods reliably to the facts of this case. He did not testify at any time that he was testifying to an absolute. His testimony was, this is my opinion based on everything that is here. He referred to articles that described straightening of the spine when there was an injury. He referred to articles saying that with an injury, there would be soft tissue swelling, edema, hemorrhage, and no one said, at least I didn't find anything in the record where any doctor said there was any straightening or reversal of the curvature in Ms. Petroni's spine. I think these are the highlights that I would like to present to the court. I don't know if you have any questions at all, but here the court did not abuse its discretion in admitting the testimony of Dr. Foley, or with respect to the records of Dr. Afield, which admittedly, by his own admission, included at least 2 records that did apply to plaintiff, showing that she had pre-existing problems to which she had not acknowledged. So we just would urge the court to affirm. Thank you.
Thank you, Ms. Wheeler. Mr. Mehring, you have about your 4 minutes for rebuttal. Whenever you're ready, please proceed. Oh, Mr. Mehring, you're muted, sir. If you could unmute your microphone. All right. Very good, sir. You've got
That's fine. Thank you. Regarding the June 4, 2009 record regarding apparently pulled a disc in her back or a muscle, she never had an MRI. She never pulled a disc. That was not her. But arguing that Dr. Afield testified that he thought it was her, which we disagree it was, the Lorset that she had was for her migraines that she had before this accident. She always acknowledged. He gave her Lorset for years for her migraine headaches. That's what the Lorset was for. That maybe that one record could come in, not these other records regarding all of these conditions she never had. Fibromyalgia, RSD, that's horrendously prejudicial. Let's see. Oh, and the fact that I moved the records into evidence, counsel wasn't there at the trial. We stipulated to what records we would put in. We agreed to disagree. We had a very specific order. We had to go through all these records with a fine-tooth comb after we had the hearing with the judge about the admissibility with Dr. Afield. The judge specified which ones come in, and we worked well together with counsel. And that's why I put them in, because we agreed to disagree, maintaining that I was disagreeing with these records, but I needed to do it so that I could call Dr. Ayfield to counteract the records as best I could. I had to call him to say that they weren't her, but I put them in because we stipulated that that's what the judge ruled. That's why I put them in. See, and I was informed that I had to call him in my case in chief, that I probably wouldn't be allowed to call him in rebuttal by the court. So that's why we did it that way. Correlations with the records and with the films. Again, Dr. Foley kept saying that he reviewed the records and he correlated them with her findings. Well, what exactly did he correlate them with? Because if he's saying that these degenerative changes were pre-existing and they were the cause of her pain, what record said that she had any pain before this accident? He acknowledged there was not a single record indicating that she had neck pain or back pain before this accident. It's not there. And that indicates he says he reviewed the records, but not once did he specify a single record that he was relying on. All he said was, I'm relying on the records generally as a background to these films. He relied on the films. He actually testified in this trial over objection that in his opinion, she was having pain in her neck and her back before this accident ever occurred. He would expect her to have symptomatology, more likely than not, even though she never went and had a medical record that showed it. She never got any treatment for it, but he would expect her to have pain. Where is that from? That is completely out of thin air. His pure opinion based upon nothing except films saying that she had degenerative changes. And she testified she's never had back pain or neck pain like that before this accident. That is completely improper. The straightening of the curvature of the neck, the lack thereof, showing a lack of muscle spasm. We had the testimony at the hearing of Dr. Herbst on the November 14, 2014 Daubert hearing. Herbst testified personally whether the herniation was newly caused by a motor vehicle accident just because an MRI study shows long-standing degenerative changes like osteophytes and desiccation, which take a long time to occur. The trauma of a car accident could cause a herniated spinal disc superimposed in addition to pre-existing osteophytes and desiccated findings. There is no way to say a disc herniation is old or new just because there are surrounding old standing osteophytes and desiccated anatomy.
And if I may, Mr. Maring, you're really right now just run out of your rebuttal time. So if you want to wrap it up very quickly to conclude.
Okay. The issue is that Dr. Foley testified more likely than not that the trauma did not cause the accident. He acknowledged that it's possible that the disc herniation could have occurred from this accident, but based upon all of the surrounding degenerative changes, it was his opinion more likely than not that it was caused by degenerative conditions. And there is no evidence for that whatsoever. It can be caused by the trauma of an accident. You cannot look at a film and tell whether or not the herniation was caused before or after the date of the accident. And there are no medical records anywhere to support that she had the neck and back problems she had following this accident, immediately following this accident. So they were late in time versus before this accident. Dr. Foley admitted and acknowledged that she had no history of these symptoms before this accident.
All right, Mr. Mayor.
Thank you.
Thank you both, and thank you for appearing in our virtual remote courtrooms. So at this time, what we're going to be asking you is to please, we're going to get the next case